This is Right to Life Radio with John Girardi on Power Talk 96.7 and AM 1400, a production of the Right to Life of Central California. And now, here's your host, John Girardi.
Right to Life Radio is proudly sponsored by Dizon Medicine and Dizon Medicine Urgent Care Plus. Thank you to the deep men, the deep voice men, the deep men voice from Jonathan Keller and myself. This is Right to Life Radio. Thank you all so much for listening. A production, as always, of Right to Life of Central California. You can go to rtlcc.org to learn more about us at Right to Life of Central California. Hey, one of the things I want to highlight for you all, if you're listening to this show, is that we at Right to Life of Central California are taking a bus on Wednesday to Sacramento for the California March for Life. The California March for Life. This is a new annual event that will take place in Sacramento, California. And the focus of the event is on California state issues. So a lot of the bad bills that are before the California legislature, we will be engaging with state lawmakers, marching around the California state capitol. Should be a really excellent event. We'll be leaving from Holy Spirit Catholic Church in Fresno. We've got a bus through. We've got a bus, and we're going up to Sacramento. So we'll be leaving at 6:30 a.m. on Wednesday, August 25th, from Holy Spirit Catholic Church. If you would like a seat on the bus, and we have seats available, give us a call at Right to Life of Central California on, if you're listening to this show on Saturday morning, give us a call on Monday morning. Our number is 559-229-2229. All right. With that out of the way, let's get down to business. I want to discuss today I wanted this to be sort of an evergreen episode. Jonathan Keller's out. There's not a ton of news on the pro-life front going around. But one of the things I like to do occasionally is to do this show, where I give sort of an in-depth explanation as a pro-life attorney about Roe v. Wade and what it did. Now, I think some people have a general sense of what Roe v. Wade is. Oh, Roe v. Wade's the Supreme Court case that legalized abortion. But it's kind of a complicated explanation of what exactly it did, what exactly its sister case did. Its sister case was called Doe versus Bolton. And there's a lot of sort of details involved with it, and I think if there's anything this show can do, it can help educate people about the abortion question, and especially abortion as a political topic and as a legal topic. I think I'm kind of uniquely positioned among Fresno radio people to sort of explain it. So that's what I'd like to do today, is to give a sort of more in-depth explanation about how exactly Roe v. Wade worked and what exactly it did. So let's first get started by talking about some of the background history of Roe v. Wade. I don't think we can really fully understand Roe v. Wade unless we understand and appreciate the history of abortion in America before the 1970s. And the best way to understand that is by reading this enormous book. For those of you watching on YouTube, and you can watch this show on YouTube, youtube.com/righttolifeca. I am holding in my hand here this big fat book. It's called Dispelling the Myths of Abortion History by Joseph Della Penna. Those who listen to the show carefully will know I talked about Joseph Della Penna a couple of weeks ago. Joseph Della Penna is a longtime law school professor at Villanova, and he actually submitted an amicus brief to the Supreme Court about their upcoming Dobbs case about the history of abortion law. And his book, Dispelling the Myths of Abortion History, is a really important work. Basically, what it does is it counteracts the major historical thesis that the justices on the Supreme Court during Roe v. Wade, that they affirmed. Basically, the justices in Roe v. Wade came to accept a bad, faulty, incorrect history of how abortion was treated in the United States. They sort of had this sense that abortion had historically kind of been recognized as a right, as a right that American women had. And they did this somewhat somewhat appealing to a lack of evidence, because the legal records and evidence that we have for abortion, there's not a ton of records relating to abortion in early American legal history. So they were saying, well, we don't have any evidence to show that it was outlawed, so it must have been a constitutional right. So they made a lot of bad arguments about the nature of abortion in early American history, and Joseph Della Penna kind of dispels that. So let me sort of describe what the legal status of abortion was in early America. And one of the important things to recognize about American law, America is what's called a common law country. A common law country. The common law tradition is a legal tradition that sort of originated from England, and many of England's former territories or Commonwealth countries like Canada, Australia, etc., but also the United States as a former British possession, we inherited the British common law tradition. And common law is characterized as basically judge-made law, that early English law did not have, a big code book, a big book full of statutes. Here are all the rules and laws by which we're governed. Legal doctrines would be developed by judges examining individual cases and developing a doctrine for how you define X, Y, or Z legal principle, and that these decisions would be handed down from judge to judge in a system of precedent. And this was how law was often made. Law wasn't only made via statute, wasn't only made by acts of parliament or acts, royal decrees. It was made by judges examining cases. A lot of the basic principles of American law today were developed out of the common law. A lot of the sort of textbook definition of, murder is a homicide with malice aforethought. Burglary is breaking and entering at night with intent to commit a felony inside. All of these sort of textbook definitions we have for various kinds of crimes and various kinds of legal doctrines, a lot of them come to us from the common law. The United States at the time of its founding did not chuck out the entire British legal tradition that preexisted American law back when America was a colonial British possession. In fact, to the contrary, American law embraced the British common law tradition under which they were being governed, under which they were living. They incorporated the common law as a part of American law. And to this day, as I said, our law is very much influenced by the common law, and we have our own sort of common law system of precedent and the significance of a prior decision from a higher court binding on a lower court, that we still live under that common law tradition. Now, often when people will say, a lot of times legal scholars will be discussing an issue and they will say, at common law, this or that was disfavored. And what they mean, usually in the American context, is at the time of our founding, when we brought in the common law, how did legal decisions, how did judges view X, Y, or Z practice? So at common law, one of the questions that the Supreme Court in Roe v. Wade considered was, how was abortion viewed at common law? And they came to the conclusion that because there wasn't a lot of evidence out there, that abortion must have been favored at common law. That there wasn't much record of criminal prosecution. It seems like there was not much record of criminal prosecution. Really, we don't have a lot of records, period, because of time. A lot of records got lost in the Civil War. And, we just don't have a lot of records. And the court in Roe v. Wade came to this conclusion that abortion must have been viewed as a kind of right that American women had, a right that would ultimately be changed in the 19th century when every state began to pass statutes, laws enacted by the legislatures of the various states, laws drafted by the legislatures, signed by their governors, that explicitly outlawed abortion. And a lot of those laws were written in the middle of the 19th century, basically before, during, and after the Civil War. Well, it's just not true that America at the time of the founding thought that abortion was just hunky-dory. to the contrary. One of the things we know about abortion is that before the advent of antibiotics, genuine abortion, killing of a fetus or an embryo, was extremely difficult to do, and for that reason was likely not very common as a form of birth control. Even going all the way back to Roman times, probably the most common form of birth control, if you will, in Roman times was this practice called exposure. Just leave the baby to die. Don't provide the baby with care. And this is... It is unlikely in an era before antibiotics that people were having abortions just left, right, and center. Okay, the only ways you could perform an abortion would be to hit the woman to artificially induce a miscarriage, or perform some kind of rudimentary, unhygienic surgery that carried a huge risk of infection, or give the woman some kind of poison, which was just as likely to poison her as it was her baby. So abortion was just not very common in late 18th century America. However, what Joseph Della Penna does lay out is that it wasn't completely unheard of, and that there actually are more cases both in England and in early America talking about abortion and viewing abortion as a criminal act. He goes back all the way to the 16th century Britain, where abortion was considered a capital offense. Usually a capital offense for the doctor. And when I say a capital offense, I mean exactly. So all the way back to the 16th century British common law, it was viewed as an offense punishable by death. And what Della Penna sort of lays out is that far from, while some of the criminal penalties for abortion seemed to differ, in some instances, abortions before what's called quickening were treated a bit more lightly than abortion after quickening. Quickening is the point in the pregnancy where the woman can start to feel the baby moving. And before we fully understood when and how exactly mammalian life began, we thought that quickening might have been the point at which human beings actually began to live. That to quicken, or the quick, is sort of an older English word that means alive, the quick and the dead, for example. So what Della Penna says is, no, early in American history, abortion was never considered a right. Now, when we come back, we're going to move on to the Civil War era. The Civil War era in which every state in the Union passed laws to outlaw abortion. That's next, right here on Right to Life Radio, a production of Right to Life Central California. We'll see you after the break. Thank you all so much for tuning in. A production, as always, of Right to Life of Central California, rtlcc.org. Again, we're going to Sacramento for the California March for Life on Wednesday, August 25th. If you want to join us, give us a call at Right to Life of Central California, or you can go to the website and sign up right there, rtlcc.org. If you want to join us in Sacramento on Wednesday, August 25th to go to the California March for Life. All right. I'm going to talk much more in depth about the history of abortion in the United States in today's show. I think as the Supreme Court is going to be hearing the Dobbs case over the course of this year, I think that people need to have a better sense of how abortion law works and how abortion law functions in the United States. So I'm trying to do this sort of evergreen episode to sort of explain to people the genuine history of what Roe v. Wade did and how we got to where we are, which is a situation in the United States where abortion is legal for all 9 months of pregnancy for any reason, and with minimal ability by state governments to genuinely just ban abortion. So we talked about abortion at the time of America's founding. Abortion was disfavored at the so-called common law. Judges would impose penalties on people for getting abortions, whether it was before quickening, the point in pregnancy where a woman can feel her child moving, or after quickening. It did not matter. Abortion was still viewed as a criminal offense. We then go to the next big significant historical point is the Civil War era. Now, around the time before, during, and after the Civil War, this was shortly after, earlier in the 19th century, scientists had really finally decisively discovered when human life began, when mammal life really began, when an egg cell and a sperm cell hit, boom, you have a whole new human organism, the zygote. And this had only been conclusively demonstrated and shown and enacted in the 19th century, and this resulted in kind of a shift in how people started to think about human life in the womb. Everybody, from scientists to the Catholic Church, everyone was kind of confused about when exactly human life began, and it wasn't until the 19th century that we really decisively learned it began right at the moment of conception. So you saw a lot of things change in the 19th century. In the 19th century, you saw the Catholic Church, for example, beef up the kinds of canonical penalties it would impose on people who got an abortion, particularly on doctors who performed abortions. But you saw this revolution in the way churches thought about it. You also saw a revolution in the way some doctors thought about it, most notably Horatio Storer, the longtime head of the American Medical at that time, the head of the American Medical Association, who basically went on a nationwide campaign in the United States to urge states to outlaw the practice of abortion. Now, abortion was still in a pre-antibiotic society, probably not very widely practiced. It was just very difficult and dangerous to do without threatening the mom's life. But it was not unheard of. And Dr. Storer basically spearheaded this campaign to outlaw abortion. And almost every state in the Union, in the time before, during, and after the Civil War, wound up passing statutes outlawing abortion. Now, this is significant. The time of the Civil War. The 14th Amendment, which was ratified after the Civil War, would go on to be used in the 1970s in Roe v. Wade, and then later in 1992, Planned Parenthood versus Casey. The 14th Amendment would be used as the basis underlying legal abortion. The 14th Amendment, this amendment to the Constitution, ratified shortly after the Civil War. And the important thing to remember is this. The people who ratified the 14th Amendment, the people who drafted the 14th Amendment, the states that ratified the 14th Amendment, they did not think that the 14th Amendment should be viewed as upholding legal abortion. Far from it. Some of the same people who ratified the 14th Amendment were, in fact, the very people who passed these state laws outlawing abortion. We're going to dig into the 14th Amendment, what it is and what it did, and how it was used to justify abortion next. This is Right to Life Radio, right here on Power Talk 96.7 and AM 1400. Thank you all so much for tuning in. All right. Today's show, we are doing an in-depth look at Roe v. Wade. How did Roe v. Wade come to be? And I've been giving sort of the historical context for Roe v. Wade. And we now come to the thorny issue of the 14th Amendment. The 14th Amendment was the basis under which the Roe v. Wade decision was decided. Roe v. Wade basically, the end result of Roe v. Wade was basically that the 14th Amendment, in its due process clause, upholds a legal right to abortion. And so I want to drill into that, because that's essentially, that's the core of Roe v. Wade. The core of Roe v. Wade is that the 14th Amendment due process clause protects a fundamental right of a woman to have an abortion. Now, as I described in the last segment, the 14th Amendment was ratified after the Civil War. And both before, during, and after the ratification of the 14th Amendment, every state in the Union was passing laws to outlaw abortion. So nobody around the actual ratification of the 14th Amendment thought that it had any bearing on abortion or thought at all that its ratification should be construed as upholding a right to abortion. It almost goes without saying that clearly nobody in the 19th century was like, oh, yes, the 14th Amendment, we're ratifying a woman's right to abortion. But it's significant. In fact, the state of Ohio, in the very same legislative session where the members of the Ohio legislature ratified the 14th Amendment, they also passed a law that increased criminal penalties for abortion. So when we talk about the framers of the Constitution, you sometimes, it's not always just the people from the 18th century. You're sometimes talking about the framers of the various amendments to the Constitution, okay? And the various amendments to the Constitution were not all ratified in the late 18th century, okay? The 14th Amendment was ratified right after the Civil War. The framers of the 14th Amendment, the people who actually voted to ratify the 14th Amendment, clearly didn't think the 14th Amendment was doing anything to outlaw abortion. Now, what does the 14th Amendment actually do? What does the 14th Amendment actually say? The relevant portion of the 14th Amendment is this section called the Due Process Clause. And the Due Process Clause is maybe the most controverted bit of the whole Constitution of the United States. Maybe there's some other part. Maybe the Interstate Commerce Clause is more controversial because that has been used to wildly expand federal government power. But the Due Process Clause of the 14th Amendment is maybe the most controverted part of the Constitution. The 14th Amendment due process and equal protection clauses. In fact, I had a whole semester of law school where basically we only talked about the due process and equal protection clauses of the 14th Amendment. Basically, we had a whole semester's worth of American law that originated just from those two little sections of the 14th Amendment. Now, the Due Process Clause says that no state shall deprive any person of life, liberty, or property without due process of law. That's what it says. So let's look at some of the important parts. First, it says that no state shall deprive any person of life, liberty, or property without due process of law. This was a federal mandate, a federal constitutional mandate on state laws and state lawmaking. That's really important. By making this the basis of their decision to uphold abortion, part of what the Supreme Court did in Roe v. Wade was impose their viewpoint on not just federal law, but on every single state legislature in the country. So when they say abortion is a constitutional right, this binds every state legislative body in the country. If the Supreme Court says Roe v. Wade is protected under the 14th Amendment, if the Supreme Court says that abortion is protected as a fundamental right under the 14th Amendment, that means that your individual state can't pass its own law banning abortion or banning abortion after the first trimester or whatever. You are bound by this Supreme Court decision, okay? So, 14th Amendment says no state shall deprive any person of life, liberty, or property without due process of law. What does that phrase, due process of law, mean? The context here is important. The 13th Amendment, which outlawed slavery, the 15th Amendment, which gave newly freed black slaves the right to vote and the rights of citizenship, were, along with the 14th Amendment, imposed upon the southern states. Basically, you southern states, if you want to come back into the Union, you have to ratify the 13th, 14th, and 15th Amendments. That's the price of readmission. So the 13th Amendment abolished slavery. The 15th Amendment made black people voters and citizens. The 14th Amendment was a bit more of a mixed sort of grab bag of different kinds of provisions, one of which was the Due Process Clause. And given that historical context, it's kind of clear what the 14th Amendment framers were aiming at. It's a federal mandate on all these states, including those rebellious southern states that we need to bring into line, that if you're an American state, basically, you have to have due process of law. You cannot deprive someone of their life, execute them. You cannot deprive someone of their liberty, throw them in jail. And you can't deprive someone of their property, seize their assets, fine them, whatever, without due process of law. Fair process of law might be another way to phrase it. Fair judicial proceedings. Fair proceedings of justice. Due process. Okay? So, if anything, the 14th Amendment is a kind of, and the way a lot of more originalist thinkers, and just me, myself, just looking at the words and reading them, this is seemingly a kind of procedural guarantee. Hey, you southern states don't have one system of justice for white people that has a bunch of safeguards and civil liberty protections and fair procedures. Don't have one system of justice for white people and a much less fair system of justice for black people. Kind of straightforward that this is sort of what they were aiming at. Now, it doesn't necessarily have to be, it's only protecting black people. It wasn't written that way. It was designed to protect everybody. So you cannot have unfair process. Now, the way that creative Supreme Court justices, usually creative liberal Supreme Court justices from the 20th century, the way that they would look at the 14th Amendment is they would try to make this clever argument called substantive due process. And I say clever, I don't actually mean clever. I mean, I think it's a disingenuous argument. But what they would say is that for due process to exist in American society, certain kinds of rights have to be protected under law. You cannot have a fair legal culture unless certain kinds of rights are protected. So in a case about 10 years before Roe v. Wade called Griswold v. Connecticut, the Supreme Court said that privacy is one of these rights, that if you don't have a right to privacy, how can you have fair judicial processes? How can you genuinely have due process of law as protected by the 14th Amendment? How can you possibly? And so in Griswold v. Connecticut, the court created this sort of broad, vague right to privacy. Now, there are certainly private things that the Constitution protects. Some of the stuff protected by the First Amendment can be construed as private. Your right to freedom of assembly, often in private. Your right to freedom of speech is maybe you have private thoughts that you want to write down. Your right not to have soldiers quartered in your house, kind of a private thing. Your Fourth Amendment right against unreasonable searches and seizures, definitely a privacy right. But privacy writ large was never viewed as something protected by the Constitution. All kinds of things that you'd imagine are private activity were regulated by the government. Whether you think it's wise or not, fair or not, just or not, it has always been legal in the United States to prosecute various kinds of sex crimes. Even sex crimes engaged in by totally consenting parties. Various kinds of sodomy were prosecuted, not just same-sex sodomy. Adultery was prosecutable. There were all kinds of supposedly private things that were protected. So what the court did in Roe v. Wade was say that there is a fundamental constitutional right to abortion because there's a fundamental constitutional right to privacy, and the kind of thing that's protected by privacy that also includes abortion. Now, when we return, I'm going to talk about Doe v. Bolton and Planned Parenthood versus Casey, which goes sort of hand in hand with Roe v. Wade. Doe v. Bolton was Roe's sister case, decided on the same day. Planned Parenthood versus Casey was the successor case, decided in 1992. And what the new Dobbs case the case the Supreme Court's going to hear this year about the abortion issue, how it could change everything. That's next on Right to Life Radio, right here on Power Talk 96.7 AM 1400. Song about a long, tall woman in a black dress. I'm always shocked that this was a Hollies song because most of their early stuff is very, very British, and this sounds very, very American. And I did not realize this was the Hollies until several years of listening to it. Anyway, Right to Life Radio, thank you all so much. Again, our bus going to the March for Life in Sacramento, the California March for Life, is leaving Wednesday, August 25th. You can go to rtlcc.org. Go to the website to get information if you would like to come, if you'd like to sign up. We've got seats on the bus, so sign up there. And if you want to come with us, we'd be delighted to have you. We'll have a T-shirt for you. It'll be sort of a full-day round trip. We'll go to the Capitol building in Sacramento, learn about the legislative process a bit, learn about some of the bad stuff the California legislature is doing. It should be a really great event. So especially any of you with kids who might be homeschooling, this could be a really good sort of educational outing. And for those of you adults who want to learn about it. Anyway, rtlcc.org if you want to learn more. All right, to close out the show, I want to talk, we sort of described a little bit how Roe v. Wade works. Roe v. Wade based itself in the Due Process Clause of the 14th Amendment. The Due Process Clause is... It says that no state shall deprive any person of life, liberty, or property without due process of law. The interpretation of that section of the Constitution is that that a lot of liberal justices in the 20th and 21st century had, is that unless certain kinds of rights exist in American society, you cannot have due process of law, you cannot have fair legal proceedings, you cannot have a fair legal culture. And so they created this sort of amorphous concept of a right to privacy, sort of privacy unbounded and writ large. And the justices in Roe v. Wade basically said that hidden within the right to privacy that they had sort of made up 10 years earlier in Griswold versus Connecticut, hidden within this right to privacy is a right to have abortion. Basically, they went back in their faulty view of American history. They said, look, people were having abortions in early America. It was protected under law. It was viewed as a right. It was not protected under law. It was not viewed as a right. And they said, listen, this is part of privacy. These are sort of private medical decisions, and we shouldn't intervene. We don't really know when life begins. How can we know? So therefore, we're going to uphold this as part of privacy, and therefore it's a fundamental constitutional right. And that phrase, fundamental constitutional right, is significant. It gave abortion this enormously high level of legal protection. Now, so they took the 14th Amendment, they found hidden in it a right to privacy. They found hidden within a right to privacy a right to make these kinds of particular, quote, medical decisions. And even within that, they decided to structure the right to abortion along the trimester system, something that was probably not even really that well known in the 19th century when they ratified the 14th Amendment. So basically what the court did in Roe v. Wade, which, as you can tell, this is not really interpreting the law, finding what the law was actually saying at the time. This is writing new law. This is coming up with a statute, basically. The Supreme Court in Roe v. Wade said, well, in the first trimester, states and the federal government, they can't regulate abortion at all. In the second trimester, you can maybe pass some health and safety restrictions on abortion for the sake of mom. And then in the third trimester, you can ban abortion as long as you have an exception for abortions that threaten a woman's health. Doe versus Bolton defined what a woman's health is. Doe versus Bolton is another Supreme Court case that was issued the same day as Roe v. Wade, January 22nd, 1973. Roe v. Wade was looking at a Texas abortion statute. Doe versus Bolton was looking at a Georgia abortion statute. And what the court said in Doe, they were talking about, well, what does it mean for a woman's health to be threatened? Roe v. Wade says you can ban abortion in the third trimester except for pregnancies that threaten a woman's health. What does health mean? And they defined health in this unbelievably broad fashion. Literally every unwanted pregnancy implicates a woman's health. Familial health, mental health, psychological health. Familial health, which basically just means my family dynamic would be upset if I had this baby. And the person who determines if a woman's health is threatened is the doctor, i.e. the person financially interested in you getting an abortion. So the long and short of it is, if you can only ban abortion in the third trimester, and your ban has to include an exception that's so big as to encompass every single pregnancy, then you can't ban abortion at all. Also, because this was the Supreme Court interpreting the Constitution, the supreme law of the land, a constitutional provision that binds states, the 14th Amendment. The 14th Amendment bound states. It said states have to have due process of law, can't deprive someone of life, liberty, or property without due process of law. Because of all that, this interpretation of the 14th Amendment as containing a fundamental constitutional right to abortion was imposed on every state legislature. So Texas, even if it wanted to, can't just ban abortion after the first trimester. They can't. They are bound by this incorrect interpretation of the Constitution. This brings us to 1992, Planned Parenthood versus Casey. In Planned Parenthood versus Casey, the Supreme Court basically changed its reasoning for Roe v. Wade, but came to the same result. The 14th Amendment, this time in its provision of liberty, that no person shall be deprived of life, liberty, or property without due process of law. Justice Kennedy, along with Sandra Day O'Connor and David Souter, thought that the right to have an abortion was part of liberty. In fact, the right to define when human life begins is part of liberty. And to act on your own self-definition for another person of when life begins. But it preserves, now it changes the system from a trimester structure to a viability structure. So before viability, states cannot ban abortion at all. After viability, they can ban abortion, but again, they need to have an exception available for women whose health is threatened by abortion. And again, the Doe v. Bolton definition of abortion, health, holds. So again, because they were interpreting the 14th Amendment, and the 14th Amendment applies to every single state, we're in a position right now where no state can just ban abortion. No state can ban abortion after the second trimester. No state can ban abortion after the midway point of pregnancy. No state can ban abortion after the first trimester. No state can ban abortions chosen for reasons of the child's race or sex. And this is what the Dobbs case represents. In the Dobbs case, which the Supreme Court will decide next June, the court will answer the question, was Roe v. Wade, was Planned Parenthood versus Casey correctly decided or incorrectly decided? And if they answer that Roe and Planned Parenthood versus Casey were incorrect, they will turn over to individual states the ability to regulate abortion as they see fit. Let's pray that that at least happens. That'll do it for Right to Life Radio. We'll see you next week right here on Power Talk.